Uh, the next speaker in this session is Professor Meera Adya. She's Director of Research at the Burton Blatt Institute, and her particular area of specialisation is in employment and discrimination. She has involved herself in interdisciplinary research focusing on social problems through empirical exploration of the factors that affect decision-making and the testing of remedies within the existing legal framework. She's also she earned a law degree, and she holds a doctorate in social psychology from the University of Nebraska at Lincoln, which is among the foremost interdisciplinary programs in psychology and law. On your behalf, I'd like to thank her very much for having come, and also look forward to her contribution, and that will focus particularly on the GINA Act in its context and its effectiveness so far.
Okay. Could I get some help with the monitor? I'm sorry, it's not showing the top of the slide. Is it? Do you have your? It's right there. Oh yeah. Mm-hmm. Okay. Okay. I don't know why it's not showing the title view. Maybe it's just this slide.
Oh, sorry, that's not yours, is it?
That's mine.
Oh, that's yours. Okay.
There we go. Thank you. Something's wrong with my first slide. I apologize. The title's missing. But really what I'll be focusing on is genetic discrimination, largely within the employment context, and a lot of psychology, social psychology, cognitive psychology, decision-making type impacts related to that. I'll touch upon the law some, but I knew Michael would cover it expertly, so I didn't want to go too far. Can everybody hear me? Am I using the microphone well? Okay. Well, thank you, everybody, for having me here, and Gerard and Aisling for inviting me. I've been very excited to come and get back into these issues. It's been some time and some distance. I actually did my dissertation on this topic in 2004, and I'm happy to be able to return to this body of work. At the Burton Blatt Institute, we largely focus on disability and employment issues and disability policy and law in general, but my focus is disability and employment. So this is a bit of a return to this issue for me, and forgive me if I'm rusty with some of the elements, including my own dissertation. So as you can see, I've got a little cartoon up here that I think we've got a lot of these that abound that just sort of portends of how information could be used in an employment context, almost literally as though one was reading someone's resume and saying, oh, great, you've had this work experience and you've got these skill sets, and oh, no, look at what it might mean for me 5, 10, 15 years from now if I were to hire you. Okay, so this is just a little slide that demonstrates at the outset of the Human Genome Project, when we were thinking about it, how very interdisciplinary and multidisciplinary it could be, and I think we're seeing that here today as well with all of our speakers. One of the disciplines that is impacted, that's mentioned there, is health risks, and I think that's where I really pick up on my interest in this. It was thinking about how we calculate these health risks and how we use them in various applied contexts, including employment. And I think there's a lot of empirical questions that can be asked there. Certainly, there are a lot of moral questions, there are a lot of policy-oriented questions, but my background is to say, if there's a question like that, can we answer it using some research, using experimentation and other methods to say, well, this is really, if we're worried about people making decisions in this manner, what do we know about whether they are likely to? And then more sophisticated follow-up questions. So in an employment context, if people were to get access to genetic information, would they use it? Certainly, at the time I began my work, there was much ballyhoo in philosophical literatures and in legal literatures concerns about this. But there wasn't a lot of empiricism investigating the potentiality for it or how it would work. Would people use it all the time? Would they use it to make hiring and firing decisions? Would they use it to make other kinds of decisions, such as promotions, or how one sets a salary, or what parameters you put around the way somebody does work? From a disability perspective, would there ever be a point in time when accommodations would play into it, and would it impact the decisions that are made about reasonable accommodations, a term of art we use in the US when it comes to disability and employment? And can it be remediated? So if we were to be concerned about the misuse of information, could we train people sufficiently well in genetics, in how to perceive the risks, in how to think about the statistical predictive value of what it is we're learning, and could we get them making accurate decisions. So from a moral perspective, if we wanted to say this isn't binary, there's a continuum here, and there may be a point along the continuum similar to insurance where there's a legitimate basis for making different decisions, discriminating in the sense of cognitive discrimination, distinguishing between people, then can we get people to do that accurately and not worry about inaccuracies? So I think this has been brought up by former speakers in a much more expert way than I'm able to present, but certainly there are a lot of genetic tests that are being discussed, that are becoming available, that people are concerned about. And what's really interesting, at least within the research side of things, if not in the actual applied contexts, we're seeing even so-called personality or behavioral characteristics that are being impacted by genetics. So we have a gene that's specifically been identified as being related to thrill-seeking or novelty-seeking, and some people are now saying, well, that gene might be linked to a whole host of behaviors, and within a variety of contexts, including employment, those behaviors could either be advantages or they could be concerns. So if you do have this novelty-seeking gene, are you more likely to take big risks and be a fantastic CEO, or are you more likely to take big risks and be concerning? And you don't want someone who's at the helm of your company and all the money that's available to them taking risks and maybe gambling and losing. Are they more likely to have addictive personalities that could be a problem for you in your workplace? Are you worried about gambling? Are you worried about drug abuse or alcoholism? And there's a lot of research that at this point, it's obviously way too early to really be used in an applied context, but people are interested and they're starting to try to say, well, I think we can predict these things. The concern is, if it's interesting in a research world, is it good enough yet to be used in these kinds of applied contexts for these kinds of outcomes and decisions? And we might get there before it maybe is really ripe for that kind of use. Speaking of the late Honorable Commissioner of the EEOC, the Equal Employment Opportunity Commission, Paul Miller, he had a great quote with respect to this, and that was that workers do fear that this employment, that employers will use genetic information to try and lower their insurance costs by weeding out individuals who might have certain heritable conditions, and that there was hard and anecdotal information that people really were fearing this. And I think we've discussed that already today, that there's a lot of research out there demonstrating there's a fear of discrimination occurring. It's hard to understand at what level that discrimination may genuinely be occurring. But I think one part of this quote that's really interesting that we'll get back to over the course of the presentation a few times is that the problem might only get worse as technology develops. So perhaps as technology gets more and more sophisticated, there may be more and more reason to be concerned about what kinds of information might be used against us, so to speak. And I think with respect to GINA, there's a concern that maybe it will quickly become insufficient because it will be outdated from a scientific perspective. It won't be able to keep up with what people will ultimately be able to know about us or how they will be able to use that information. So many speakers have brought this up too. I'll move quickly through this, but really the idea of genetic discrimination and its possibilities. And certainly we do know from our early 1900s across many countries. Michael mentioned the US. I'm originally from Canada, and I know, unfortunately, we had a history there as well of forced sterilization and segregation on the basis of biological information. So we definitely like to use this information and get ahead of ourselves before we suddenly stop ourselves. In the late 1900s and moving onward now, we have pre-implantation genetic diagnosis. A lot of folks are looking at fertility treatments, and they may then want to select embryos. I think one of our questions came up, for example, even if the person doesn't want to screen out embryos, would IVF clinics potentially want to screen out embryos? And that's, of course, deeply concerning, but there is this idea of designer babies that we might create. So really the idea of genetic information being used is clear we do that. Anecdotal examples, again, this is what I'm mentioning, that there is perceptions of discrimination occurring in employment, in insurance. I've seen some literature that suggests that folks, even in adoption cases, were being discriminated against because there was a concern that, well, if you're going to get sick, you're going to be too sick to take care of this child, so maybe you don't deserve to get a child. And if these are happening, this is of concern, and the question is then, is legislation taking care to protect against these kinds of things? GINA speaks to insurance, it speaks to employment, but what are all the extensive things that it's not speaking to, some of which our prior speakers have raised? The idea of in a criminal context, how that information is being used, in an immigration context, how that information is being used. So a lot of this anecdotal information is coming from a variety of sources. We have survey research that is often extensively going on. We have news stories that are starting to report cases of what's happening to individuals. We have congressional testimony and meetings and hearings that have been taking place in the lead up to GINA. And we have online support groups where people are reaching out. They're concerned. They may already have some concern about a genetic predisposition, but they don't know what to do, and they're worried that they might be discriminated against. Certainly, there are relevant and legal bases to evaluate employees that we already know about, and the question is then, how far are these going to continue to be expanded, and where will they bump up into GINA? As Michael pointed out, the contours of the restrictions and the exceptions that are there aren't clear yet, and so there is room for things that we may think when GINA first came on the scene, it's going to take care of this. I think that we can see as we go down the road that maybe it won't. Maybe it won't take care of everything. So, for example, we can do personality tests in employment context. Then there's regulation and there's litigation that's dictated how far we can use that information, but the reality is we can use that information to discriminate against individuals. There's blood or urine tests that can detect drugs that are used in the workplace, obviously for safety reasons. And as we've talked about today already, genetic monitoring is on the scene. There's a notion that there can be a safety implication for doing this in a workplace. So the likelihood of that occurring, it's still not foreclosed. In contemporary legal examples, Michael mentioned these. In fact, you mentioned one I didn't know about, the case of, I think it was lung cancer you mentioned. Yeah. Mm-hmm. But we had, of course, Norman Bloodsaw, that was pre-GINA, and we had Burlington Northern, and that was the carpal tunnel case. And in both these cases, what you really have is this exactly what people were worried about, right? That employers are going to be concerned about your performance in an employment context and or their insurance costs, which is precisely what drove the Burlington Northern case. There was a lot of repetitive stress injury by the nature of the work that was being done there, and the insurance costs were rising and rising for Burlington Northern. So it began testing people, and when one employee refused to get tested, that's when all of the litigation started there, and it was ultimately settled out of court. There's recently been another case in the U.S. that's also come out within the media, and following up on it, I have not been able to see where it stands in terms of its litigation process. I don't know if settlement talks are in order. It's only about a year old. But this was an example of a woman who obtained a genetic test for the BRCA genes. It was in her, cancer was in her family, breast cancer, and so she took the test and she did test positive. This was in 2004. She did nothing with this information for 5 years, and then by 2009, her sisters had also developed breast cancer. And at that point, her doctor said, you probably have an 80% chance if you don't do something about this, if you don't have preventative mastectomies. So she made the decision at that point to do so, which meant that she had to leave work for a period of time to be able to get the treatment that she needed. And she had to disclose to her employer that she was doing this and that she had a legitimate medical reason for leaving the workplace. This occurred in the August of 2009. Up until that point, she had received nothing but positive performance reviews. Starting at that point, the way that the employer interacted with her began to change. So she leaves the workplace and to get her treatment, and she brings in a consultant who happens to be a friend of the CEO's and recommended by the CEO's to cover her job until she can return a month later. She returns, and the consultant doesn't leave the organization but stays on board and is made her supervisor. And her responsibilities start to diminish, and so in January of 2010, she files a complaint with HR. In February, she has to get secondary ongoing treatment, and so she has to leave work again for a few weeks, and she does so. In March, she comes back, and she's getting a series of negative performance reviews now from this new supervisor, and then she's ultimately fired. She did file. She originally sought out counsel, and representation to file under GINA. And what I haven't seen yet is the ongoing disposition of that case. But in terms of understanding the effectiveness of GINA, this may be one of those first test cases that we see if it continues to proceed. But certainly the facts of the story, and this is all alleged at the moment, the facts of the story do represent what the fear, I think, has been that prompted us to pass GINA and prompted many states to pass their own laws as well. Genetic discrimination, might it be required? So we have a case in the U.S. under the Americans with Disabilities Act where the notion that one could discriminate against someone on the basis of a health-related condition was viewed as permissible. And we know that to be the case in the disability jurisprudence. But here was a case that was really about protection of self. So the idea was not necessarily that you are being discriminated against or prevented from taking a certain position because the nature of your functional limitations may prevent you from doing the job fully and you can't be reasonably accommodated. That would be the disability jurisprudence. Here it was, this may cause harm to you, and therefore you can be excluded from this position. So that's what the court upheld there. Michael, did you say I'm getting that right? Okay. Interrupt me if I'm not, because you're the legal scholar, so please. But the concern, I think, here is could we see some analogizing to this type of jurisprudence with respect to GINA? So we had ADA, we've passed GINA, but could you see the courts taking it up and reasoning along these lines? And I'll bring up some other cases as well that relate to that. We've already heard about genetic monitoring. So, of course, genetic monitoring can be permissible in many different cases, particularly when there are environmental toxins that may impact one's health. And there are genetic susceptibilities that can be tested for. So I believe beryllium is a toxin that we might be sensitive to, and it's permissible to conduct tests to see if we're sensitive to that and then do ongoing monitoring to make sure that we continue to be safe. The Occupational Safety and Health Administration within the U.S., and I'm sure that there's many analogous entities across other countries as well, regulates safety and health of workers. So it's regulating these issues. And in terms of thinking about GINA, which is going to be regulated through the EEOC, it's thinking about things from an employment perspective. It's going to start running up into these other agencies and their rules and their regulations for what they must do. So when genetic testing is permissible for monitoring, how's that going to bump up into GINA when that information is potentially misused or misappropriated within the employment context? So back to this notion of the danger to self or others, the question is, so how far could we go with this? One of my colleagues in Syracuse at the medical school, he's a bioethicist, and he's looked at this work for some time as well, and he said, well, let's consider the example of a surgeon or a pilot who has the gene for sudden cardiac arrest, or I'm sure I'm scientifically maligning that perhaps, but a different gene that predicts the potential for sudden cardiac arrest. Would that be something that we would want to test for, that we would want to know about? Would you say if the employer shouldn't be the one to discriminate, should there be a duty to disclose? And for the physician, that might be de facto then shutting down his practice, and so really you have discriminated against him in that profession. He raises those issues, and he brings up the idea that there's a history and policy of us doing this in other contexts. So, for example, physicians with narcolepsy are banned from surgery because that might be dangerous within that context. HIV-positive surgeons must certainly disclose their status. Police officers with benign essential tremors can be discharged because of the potential for them not to be able to use their firearm safely in given circumstances. So this health and safety notion has been used many, many times to prevent people from taking certain types of employment related positions. So there's a lot that can, I think, distinguish some of those cases, but I think the idea of health and safety impacting our decision making is an important one, and I think it's one that GINA hasn't necessarily spoken to completely explicitly, and what we're going to see is now the jurisprudence is going to become really important, how cases move through the legal system. A couple other examples actually I'll give with respect to this. There's a case, it's actually from Maryland, Huber versus Howard County, and Huber was a firefighter who was dismissed because of his health condition, and he sued, and his own expert testified that really there was only a 10% chance that anything could go wrong with respect to his health condition when he was fighting fires. And the court there said there is no reason that he or his colleagues or society has to accept a 10% risk. And I think that's really interesting too, because the degree to which we get down the road of being able to have really precise statistical predictive value is still open. But let's say we get to a point where we can start attaching some ranges of numbers or fixed numbers. How will we use those numbers? Where will we set the standards and the bars? Is it going to be 10% predictive value? Is it going to be 5%? Is it going to vary depending on how you're looking at it? Is 10% good enough to exclude someone from an employment situation? Is 10% similarly good enough to start asking employers to provide reasonable accommodations, perhaps extra monitoring that otherwise wouldn't be a part of the workplace program? So the way in which we flip the context or the perspective on the situation could lead us to make different decisions. And it's going to take some thoughtfulness for us to think about what we feel are the right approaches to take there. Other examples which I think were brought up of where actual genetic discrimination has taken place or testing has been occurring, certainly the military was discussed, and that is taking place in a variety of ways. There are sports cases. So in the athletic context, we've seen baseball is doing testing, often for a variety of reasons. Basketball, there were tests. I think there was a player who played for the Bulls and was traded to the Knicks, ultimately because he refused to get a genetic test to see if he would have a sudden cardiac arrest while he was playing a game. So again, that's the health and safety concern. Uh-oh. Don't do that. Uh-oh. Does this mean I just talked too much on one slide? Go faster. What did I do?
Okay. Okay, that should be fine.
Thank you.
Okay.
Okay. So I think there are plenty of examples where this has been taking place, and now I think I think it is interesting, and Michael, you're right. So are we going to see people start to slowly learn about GINA and slowly stop some of these behaviors, or are we going to continue to see some of these behaviors and these tests and these requirements being in place because people want to test through the court system? Will those exceptions and those contours be drawn to allow for some more? Okay, well, why discriminate? Well, within the employment context, I think these are things that many scholars have often talked about and have sort of an obviousness to them, but really it's just about performance in the workplace and costs associated with that, right? A perception that someone who has a specific genetic susceptibility to a disease, a disorder, a functional limitation of some sort might in the future or might over time become absent from the workplace. They might incur lost time. They might be less productive. I might be worried about them being there but just not doing as much as I need them to do. They might leave my workplace. And after I've invested in them for 10 or 20 years and they've risen to a management level, that's a significant cost for an organization. Turnover is a big deal. Will they ask for accommodations? There's a lot of research that we've done in the U.S. with respect to the cost of accommodations showing that it can be quite low, but there's still this perception that they can be inordinate costs for employers, and so in this case that can raise that specter again. The health insurance premiums. I think the nature of how we deliver health care in the U.S. really does drive a lot of this issue. It's expensive for employers, and it continues to get expensive, and they're trying to get out ahead of it. We're seeing a lot of activity. Companies are dropping retirees, for example, from their health insurance plans where previously they offered it because they can't afford it anymore. So wherever they can, they're starting to constrict their boundaries of the responsibilities they have with respect to this. Okay, and this is where the psychologist in me will come out for a little bit. So what does past research tell us about the likelihood for past discrimination? Well, we know it occurs. It seems to be this wonderfully fundamental thing that we do, right? We make distinctions. We're categorical in nature. We're going to do that. And in some contexts where it may be appropriate to do that, it may be inappropriate in another, and we don't necessarily draw good boundaries and use information one way in one place and a different way in another place. So we know that discrimination on the basis of many other characteristics, race, and ethnicity, gender, age discrimination, a lot of these other categories that we have gone to the lengths of protecting in the U.S. under various civil rights legislation, that they still occur. We know that they're still occurring. They used to be explicit. The explicit nature of them perhaps called out for legislation, and I think that's what we still see with GINA, right? The real explicit on its face, people are going to say this, they're going to do this, and they're going to say it out loud, and they don't have a problem with that. That's what we're legislating at. And then what becomes harder and what happens over time is how effective are those pieces of legislation when it becomes implicit, when it becomes unsaid, and maybe when it becomes unconscious. So a lot of the kinds of discrimination that we thought we were legislating against and society was moving past, we now have cognitive tests, for example, that look at implicit bias and implicit associations that we make, from a decision-making perspective, particularly when we're under high cognitive load. And how many of us aren't these days? So most of the time we're busy, we're doing a lot of things, and we're making fast decisions. And when we're making fast decisions, we tend to make easy decisions. And it may not be the case that we're in an ongoing way racist or sexist, but if we're in a culture that has some racism and some sexism, then cognitively, we're almost primed to go that way faster. That will be the first association that's made in our mind, and it will take work to overcome it. If we're operating under cognitive load, we may not be so effective at working to overcome that immediate decision that got made, and it will largely be an unconscious one to us. Other line of research that I've done on pretrial publicity, really I think the bottom line from that line of work, and it's based on cognitive and memory research in general, is you don't unring bells. And I'll say that that's one of my concerns with GINA. GINA doesn't want you to access information, but for a variety of reasons, and I appreciate the compromise that had to be made there, inadvertent access, the water cooler effect, as it were. You can get information, and that's not going to be a problem. It's do you use it? But there's, I think, from the legal perspective, often an over-reliance on the notion that we can put that firewall up, that we can get access to information and yet prevent ourselves from using it. And there's a variety of applied psycholegal contexts in which it's been demonstrated we really, really super can't. So I think that would be one of my biggest concerns with respect to GINA. Let me emphasize that, super can't. Other related literature that I think is important is decision-making literature, looking at framing effects, looking at risk aversion, again, health risks. This is what's driving us, right? So when we look at this information and when we want to use it, we're trying to calculate the risk of something happening and what the outcomes related to that could be, and then what decision do we make. We don't tend to be good at this either. We tend to multiply risks out in very incorrect ways. We've seen that in a variety of psycholegal contexts and non-psycholegal contexts. Classic Kahneman and Tversky, this is Nobel Prize-winning economic literature, has demonstrated that if you frame something from the loss perspective, you will be more risk-averse than if you take the exact same likelihood of something happening, but present it from the gain perspective. So how something is framed to you, may it be your own genetic test results or may it be somebody else's genetic test results, is going to impact your decision. Same two pieces of information, framing made the difference. And we see that the incorrect ability to multiply out risks and really be sensible about what we need to do with jurors, for example. We've done some research demonstrating that when looking at the weight of DNA evidence in a legal context, jurors are presented with all the information. They're presented with base rates. They're presented with probabilities. They're told the likelihood of a false positive is this. The likelihood of a lab error was that. It all can shake out to be this, but use this information yourself because you're the ultimate decision maker. So sometimes experts might be allowed in the courtroom to speak to that. Sometimes they might not be. And the idea is that the jury should be able to handle this. But they don't. So research has looked at it and it's demonstrated that they overemphasize very, very small risks, particularly when they're multiplying them out. They start to make some mistakes. And that's going to happen in this context. You're not going to be presented with one piece of information that's incredibly dispositive. You're going to be given a range of information, and you're going to have to know how to combine it and put it all together and make a reasonable decision. So going back to the health and safety perspectives, if we were to say, okay, we want to go down that road, and we want to say this is a continuum, it's not binary, you're not allowed to ever do this, and then maybe sometimes you're allowed over here. It's going to be the degrees to which you can use this information. Can we really get people to use that information in an accurate way to the degrees that it should be used? I think this is a great a statement that can apply to many things, so I just wanted to bring it forward because I think it has implications here as well. So the notion is that, once a tool is developed, there's considerable pressures for implementation. Science is going to want to keep refining what it is that it does, right? I know this as a social scientist. When I do my research on pretrial publicity, on disability discrimination, or anything else, as soon as I'm done my one study, I know what next 3 studies I want to do because I know what the limitations of this first one were, I know what the findings raised for me as the next set of questions, and I have the tunnel vision that I want to keep understanding this. The law has to step in at a moment in time, and it has to be able to draw its boundaries on the basis of all the right available information. And in the midst of this, you're getting these tools that people are going to want to use. So that's where the law comes in and says, okay, for today's science, here's what we know, here's how you can use this tool, and here's maybe where you shouldn't. So Gina has stepped in today, but I'll return to this at the end, and I think that it was Mark Rothstein who really raised this issue. Is Gina stuck in today, or maybe even yesterday's science? Will it take care of us as science continues to progress? And again, that goes back to Paul Miller's quote that I had as well. Why might it not be that effective? So I've talked about this. There's very few single gene 100% penetrance disorders. And I'm getting out of my scientific ken here. I shouldn't be banding about these words, but I'll do it because it's on my slide. So what I know is that you really can't just get that one perfect test that says, positive over here, you're going to get Huntington's at some point in your life. Maybe for Huntington's you can, but there's very few, as I understand it, understandings that we have related to that. Instead, I think there's this model of stress diathesis, and I apologize if this isn't the right term of art to use in the genetics world. We use it in psychology when we think about the biological and environmental influences on various diseases and disorders and limitations. So we know that there's an environmental influence. And then something I have no business talking about, but I've just started to learn about and it interests me, is the notion of epigenetics. So as I understand it, you have your genes, and then you have thingamabobs, proteins perhaps, reasonable term, right? Let's sit on top of it and say, okay, we're going to read this gene, we're not going to read this gene. Are these thingamabobs covered by GINA? It's not perfectly clear. Genetic test information, as you mentioned, is a genetic test of yours, of your relatives, or the manifest disease that they have. And scientifically speaking, as I understand it, we might say literally, genetics is not epigenetics. They're 2 different things, and we need to understand them, and they work very closely in context, but they might be different. If we were to take that scientific distinction and then extrapolate it into the legal world, would we then say GINA doesn't apply? And if we do that, then are we leaving a gaping hole in terms of what we have regulated? So this is going to get at more stuff I should not be talking about, but statistical predictive value, as I've mentioned and I've brought it up a few times, where do we go with that? If this is the way that risk is working, it's not 100% for sure. We can't give people binary information, yes or no. There's an environmental influence, and we don't know how that's going to impact things. And the environmental influence, as I understand it, there's the epigenetics of it, but there's also just your behavior and whether you can mitigate any genetic susceptibilities you might have. So maybe you will get cancer, but maybe you won't. Maybe it also depends upon your exposures over your lifetime. How are we going to think about all those types of risk, and how are we going to be able to weight them in employment contexts and in other psycholegal contexts, such as an employment case that goes to the jury? How will the jury then be able to make decisions about that information? Can employers get health-based information? There's a variety of ways. So when I started first doing this work, that's what a lot of people said. They said, oh, there's no GINA yet, but there's HIPAA. Health information is protected, and employers shouldn't be getting this information anyway. Well, certainly there can be voluntary or inadvertent disclosure. There is a post-offer capacity to get the full medical information of someone. So you can get screenings, authorization, and medical records after you've conditionally made an offer of employment to someone. If someone is asking to take a leave from the workplace, under the Family Medical Leave Act in the U.S., you can verify the health-based information that you are getting, and so you may get it through that mechanism. We've talked about permissible monitoring for toxic exposures, so you might get it through that mechanism. So it really starts to come up that the issue isn't can you get this information, it's what happens when you do. And Gina steps in and says, okay, you might get it under these various mechanisms, and that's not you really requiring someone to take a genetic test, but you can't use it. And this is where we get to my level of skepticism and the notion that when people have information, that they somehow will not use it and they'll be able to prevent themselves from using it. I think some other examples were brought up, sports contexts and otherwise, health and safety and concerns why people can get access to the information. I think the Affordable Care Act, as well as apparently a provision in our recent Stimulus Act because of the economy, is Section 3002 in the American Reinvestment and Recovery Act. In ARA of 2009, it appoints a Health Information Policy Committee to examine how we can use technology to protect privacy further. And this is important because with electronic patient health records, all your information is contained in very easily portable, accessible ways. So if we were to say, okay, you can transfer all of the health information but not the genetic information, do we have the potential now to partial those out and be more careful about who's getting information when and why and where? And then we have the Affordable Care Act that I think brings up the issue of pre-existing conditions, and that might also start to speak to some of those contours of Gina, where Gina closes out, maybe that takes in and says, well, don't worry about it, at least in an insurance context. Interestingly, there's also a recent case I found out about the University of Akron, which is in Ohio, in the state of Ohio, that was requiring, it has a policy on the books that says all employees, all faculty, all staff may be asked, all contractors, to take a DNA test so that we can do criminal background checks, because their perception is that law enforcement is moving more towards DNA testing and less away from fingerprint identification for individuals. It's untested yet whether they will, A, continue this policy in light of Gina, and whether that will be permitted. If the issue is, if it's just used for the purpose of personal identification, I think it gets at what was raised before, this idea of the best available evidence to know something, that's permissible, but then you're not allowed to use it for any other employment-related reason. Will they be able to draw that firewall from a cognitive perspective? And I don't think so. Other issues at the intersection, I think, of law and psychology here with respect to genetic information. So when it comes to all of this discrimination, civil rights legislation that we have, one of the issues is the burden of proof. How do you prove the discrimination has taken place within the legal context or otherwise? And it's a fairly high burden of proof. It depends on what level, what type of characteristic we've legislated. It's impermissible to discriminate against, what kind of scrutiny might be applied to an employer's actions or policies. So with race and ethnicity, what we've seen is the court has said this is an immutable characteristic. This you get what ethnicity or race you are, and it doesn't have relevance. So we're going to look at anything that looks like race-based discrimination very, very suspiciously. With respect to gender, it's kind of lowered the bar a little bit. It said, look, sometimes you can have policies in place that might start to exclude women in disproportionate numbers to men, but that might be okay. There might be a reason to do that. So if you want to be a firefighter, they might say, look, we're going to have an employment test. You're going to have to show us that you can take a 500-pound water hose and run with it 50 meters in a certain period of time. And we might just find that men can do that more often than women who are applying for that particular job. So technically speaking, you're going to see disproportionately a class of persons being excluded from that position. But it's a reasonable test on its face. It does not have a discriminatory intent on its face, and it's related to the job, so it might be permissible. That's the kind of analysis they're going to use. And with respect to disability, I would say it's really just a rational basis test, isn't it? So they view disability as health and functional related characteristics that might be highly relevant to a job, and it might be the case that they are being disproportionately excluded from certain jobs, but maybe from their purview, fairly so. The question comes up, where will Gina fit into this? Will Gina, as Michael said, be viewed as this immutable characteristic, and so it will be viewed with the strictest scrutiny a la race? Will it be viewed as a semi-relevant characteristic if the science has sufficiently advanced so that we start to know more about its predictive power and be middling, like gender? Or will it be viewed like health information, health and functional limitation, and be viewed on a rational basis as disability? If the employer has a simple rational basis for it, it works and it fits. So I mentioned previously that discrimination has gone from explicit to often implicit unconscious actions. And as we know, we have to look at how do we decide that's really happening in the workplace. And sometimes that's by trying to look across numbers of people and say a disproportionate number of a class has been affected. That gets at this idea of disparate impact evidence in our jurisprudence. The idea that a class of persons is disparately being impacted by some policy or program of the employer. Will we be able to look at disparate impact evidence for genetic information discrimination cases? Gina is, as of yet, sort of in a hold place on it. It said, we don't want you to do this yet, but we want the EEOC to convene a commission in 2014, understand the state of the science at that time, and then decide whether it's meaningful and appropriate to do that. So the contours, again, not quite clear on Gina, and in terms of its effectiveness, not quite sure. Wellness programs. I think Michael, you brought this up as well. The behavioral health factors are increasingly becoming important for employers. They really are starting to see that primary conditions, as it were, might be leading to secondary conditions because of what they perceive are behavioral health issues. Workers that maybe experience a lower back injury, then are out of work for a period of time and become depressed about that. And the depression actually leads to higher health insurance costs for the employer than the primary injury that that the employee experienced. So they're instituting a variety of return to work and other programs, which is great from one perspective. Great to have the employee continually connected to the workplace and brought back in. Nice to have the employer want them to return to work. But there are concerns about how they go about these programs and keep their employees fit. So information from wellness programs, if you want to offer an incentive, right now what we know is the legislation speaks to the idea of them having to be voluntary. But depending on the level of incentive, and we know this from research ethics literature, at some point an incentive can become so valuable that you're really removing the voluntariness of this. So ethical research boards will often look at that issue when they're approving studies. Within the employment context, at what point do you start providing the kinds of incentives that makes voluntariness go away? How will this be interpreted by courts? It's not clear. A too conservative reading might just hamper the effectiveness of wellness programs overall. But a too liberal reading might really start to hamper Gina because it will start to provide that information again within the employment context. So I think it presents a little bit of a conundrum there. I think there's a little bit of a hole maybe between ADA and Gina that we don't quite know where it sits. Gina, of course, covers asymptomatic predisposition type of information, and ADA covers explicitly symptomatic functional limitation, major life activity type information, disability. So you have something or you have the potential for something. But what if you have a little bit of something? And again, here I'm getting past my ken of scientific medical knowledge, but the notion that you are not perfectly asymptomatic, but you are not so symptomatic, as it were, that you might be diagnosed or classified as having a disability or a functional limitation in a major life activity, which would be required for ADA to govern in the U.S. What about that in between? Who's going to cover that? Will Gina be expanded a little bit? Will ADA be expanded a little bit so that you fit under that regarded as prong? And I don't believe there's been a lot of jurisprudence under that regarded as prong as of yet. And with the ADAAA, the Amendments Act that we mentioned, the idea was really to push jurisprudence past this threshold issue of diagnosing disability in such a narrow way, or functional limitations in such a narrow way, that it was starting to exclude people, and we weren't getting to other jurisprudence on the whole disability discrimination issue. So it's still quite open where that's going to go. One of the commenters that I saw in the literature also mentioned, well, once you have this information, do you have rights on the basis of it? And I raise this with Huber and others as well. So what what does the threshold for the predictive value and for it to be used? If you have a 10% chance of a potential harm to self or others, can you be excluded from a job? If you can't be excluded from the job because it really doesn't relate to the functional requirements of the job, so there's safety there, can you still say, but I should get accommodations on the basis of this predictive value? If it happens to be sensitivity, do I get extra workplace monitoring when there's not a monitoring program in place? Are there rights conferred on the basis of genetic information? And GINA really doesn't get anywhere near that, right? It's about non-discrimination in a couple different contexts, and limited ones at that too. So it does cover insurance, but it does not cover disability insurance, it does not cover life insurance, so it's not covering all forms of insurance. It's explicitly leaving out certain things. Okay, as I mentioned, I don't really shouldn't be talking about this, but again, I think the epigenetics is one place where there's a significant gap. If one could test for these biomarkers, what we know is the explicit language of GINA is not covering it right now, and it's unclear if the courts would extend it to cover that. So that would be interesting, and there's much, if we start to get cases that go down this road, there's much other analogous jurisprudence that might come into play. This might have impacts on that level of jurisprudence as well. So one example I'll give is there's case law around DES, which was a certain drug given to pregnant women that caused significant birth defects. And it affected the second generation, and then it was becoming clear it was starting to affect the third generation. So the granddaughters of women who were given this drug. There was attempts within the U.S. Under tort law to litigate cases for the third generation, and they generally failed because there was the burden of proving causation was too difficult. There was attenuation. So from a legal perspective, we just said, no, you can't do this clearly enough. You can't predict this well enough. We're not going to let you proceed with these cases. Now, with our understanding of genetics and epigenetics, we're getting better. So will we start seeing those third generation claims? And will a fear of those second or third generation claims start causing employers to exclude people from workplaces where they may experience harms? So excessive biomonitoring policies, and indeed we have had the Johnson Controls case in the US where that occurred. Fertile women were banned from certain class of jobs because of a concern of these second or third generation potential for litigation. It didn't matter if the women were married. It didn't matter if the women were planning on having families. They were fertile, and that was concerning enough to the employer to say, we're going to ban you, but we're caretaking, right? That's why we're doing this. Now, they were ruled against from that perspective, but the specter is raised again. As we get more sophisticated in our ability to predict possible future harms, will we want to go down the road of using that information? How am I doing on time?
You're doing fine.
Okay. You know I have 40 more slides, right? Okay.
You're doing fine, but lunch is at 1 o'clock, and we're at 2 minutes past 1.
Well, now I'm starving you out. Okay, I'm going to talk really fast now. All right, I think one thing that's not covered by GINA that might be interesting to consider is, again, informational privacy as a right. Some folks have raised this, but this might also help. Perhaps this was the umbrella that can save us in a variety of different contexts. Who owns the information? How do we get to use the information? So there's a lot of commenters that have raised the issue of DNA theft that could be used in a variety of contexts. Certainly GINA doesn't protect you against that. So if you're worried about people getting your information and using it against you, you may perceive that in an employment or certain specific insurance contexts you're safe, but in a variety of other contexts you're not safe. And if GINA was meant to make people feel safe and start getting tested in advanced research, we've left some serious gaps, and people might still be scared. And so in that sense, GINA then may be ineffective. Okay, so now I'll really whiz through this, but I'll say in terms of empiricism, that's what I was interested in. Will people use this information? How will they use this information in an employment context? So to me, it was an empirically testable question. Let's just start at the beginning. If you provided employers this information, would they genuinely use it? Would they weight it when making hiring or other kinds of employment-related decisions? I asked participants to play the role of an employer. I used students, and I also worked with actual human resource personnel. And I said, look, this is a study to understand how the cognitive load of the workplace is changing in today's electronic environment, which X number of years ago when I was doing my dissertation actually made sense. Now we're so accustomed to it and so ubiquitous that we've gone past it. But the idea before was you are virtually collaborating when you work in a large organization. You're getting emails, you're getting all kinds of text messages. How are you dealing with work that's coming to you in that way? We want to see you go through a bunch of tasks, and we want to document how hard it is and how much time it takes to show that the changing nature of the workplace is affecting things. We did not want people to understand that we were evaluating their employment-related decisions that they were making. One of the tasks that they got buried in there was to sort through a series of resumes and make evaluations about candidates that had already passed a pre-hiring screen. Wanted to look at several different variables. So we were looking at, would you hire them? Would you have made the recommendation to hire them? What salary would you apportion to them? And in thinking about their productivity, what kind of ratings would you give them? How potent do you think they'll be? These were all derived from extensive employment-related literature. How active do you think that they're going to be in the workplace? And these all tap perceptions of productivity that companies can be concerned about. The cost to the bottom line in terms of productivity, in terms of absenteeism. And I'm really going to zip through my data here. But what I'll say is, overall, a set of 3 studies demonstrated that absolutely people use this health-related information. When presented with effectively equivalent resumes on the basis of education and work experience, what they distinguished between were people who had different health-related information, as would be captured by GINA in terms of genetic test or family health history. And there's often a concern in social psychological cognitive research that when you're using students, you're using a proxy population that does not map onto what it would be like in the real world. Human resource professionals are trained in the laws that are on the books, and they know what kind of information you can't use. And when I was doing this study, HIPAA was sufficient for people to say this information wouldn't be used because HIPAA would preclude us from doing so. The human resource professionals use the information more so in a discriminating fashion than students. So using a student sample wound up being a conservative proxy of the test of discrimination. If they discriminated, you're more likely to see it out in the real world population, as it were. My effect sizes are large. I won't go through all this, but I manipulated different types of functional limitations. I looked at severity. I manipulated work-relevant characteristics. So in one study, I factorially manipulated work experience to see, okay, if they're just distinguishing between the differences on paper resumes or electronic resumes, do I need to give them something to say, here's a difference and this counts, and I'm allowed to then make distinctions between people on that? They didn't use the relevant characteristic. They used the irrelevant characteristic. So look at the pattern of findings and look at my effect sizes. I'm getting an R of 0.42. You square that. What that means is that in terms of 100% of what contributes to a decision, in this case, I'm getting at about 18%. With certain other variables, we're getting at more. So here we've got 0.5, 0.51, 0.52. I'm getting at almost a quarter to a third of explaining the variance in people's decisions. These are actually quite profoundly large effect sizes for most social psychological decision-making type of research. So it shows this information was being heavily weighted. And again, it gets at statistical predictive value and risk and how we use it. Even if we decide we're allowed to use it, how far are we allowed to use it? How much should we weight it? If you say it's a relevant characteristic, should it be this relevant? Would be my question. So the summary of findings across all studies, they use the information, severity of diagnosis will matter, relevant factors like work experience won't matter. The same patterns that we see in the disability discrimination literature are evincing themselves. So concerns about cognitive or mentally related functional limitations are stronger than they are about concerns for physical related disabilities or functional limitations. My talk was supposed to be about GINA and its effectiveness. The one question I would say is, how are we going to decide what is effective? What does that mean? What outcomes do we want? Do we want to see more testing and research and less fear? Do we want to see less perceived discrimination? It certainly can't be litigation. That's a weensy bit unfair. It's a new piece of legislation. People are going to start trying it out. So litigation is going to be on the rise. What other outcomes will help us know that it's being effective? I end with a quote here from Gary Avery, who was in the Burlington Northern case, and he said, "What happened to me should not happen to anyone." And maybe that's how we can judge the effectiveness. How many more people will this happen to post-GINA? I'd like to acknowledge several colleagues who helped with this work, and then of course Jared and Aisling and Peter for making this opportunity possible for me to be here today. Thank you very much.